Hi, welcome to this Law Study Club video to help you to revise vicarious liability in tort law for A-level law. Vicarious liability can seem quite complicated, but this is mainly because the law on it has changed quite a lot in the last few decades or so. We're going to start with an introduction to vicarious liability, then we'll quickly trace some of the backstory of vicarious liability before moving on to the law as it stands now. But the good news is that the law now actually isn't too complicated. Vicarious means through or by or for someone else, like when we say that someone is living vicariously through another person. So vicarious liability means one person or organisation being held liable for a tort committed by someone else. Now through the rest of this video we're going to be using the word tortfeasor to describe the person who commits the actual tort. So in vicarious liability, one person, the defendant, is being held liable for a tort committed by someone else, the actual tortfeasor. Usually, vicarious liability involves an employer being held liable for a tort committed by one of their employees. Now, throughout lots of changes in the law on vicarious liability, the courts have held that a defendant can only be vicariously liable if it's fair to describe the relationship between the defendant and the tortfeasor as being employment, and if the tortfeasor was acting within that employment when the tort took place. What's changed over time is how those two questions have been answered. The first question is the one that has seen the most changes in the law over time. In lots of cases, this question is straightforward because the tortfeasor is clearly an employee. But where that's less obvious, the courts have been looking for consistent ways of working out whether the relationship is essentially an employment relationship or not. The control test. You might be familiar with Hawley v Luminar Leisure for the control test. The control test was based on whether the employer had detailed control over the employee. For example, could the employer decide what the employee did and when they did it? From Stevenson, Jordan and Harrison v McDonald and Evans, you might be familiar with the integration test. The integration test was based on whether the employee's work was an integral part of the business or simply an accessory to it. Now, an example for this could be a receptionist at an estate agency could be seen as integral to the business, but the person who cleans the windows of the estate agency probably wouldn't be. They would be an accessory to it. The economic reality test, and you might be familiar with Ready Mixed Concrete v the Minister of Pensions and National Insurance. The economic reality test, sometimes called the multiple test, was based on a range of factors, particularly how wages are paid and the level of control, to decide whether someone is in reality an employee. The second question, whether the tortfeasor was acting within their employment when they committed the tort, has seen less change over time, but the language used by the courts has changed. The language used to be based around whether the tortfeasor was acting in the course of employment when they committed the tort, or were they acting on a frolic of their own. Again, this is often obvious. A doctor who fails to notice a serious condition during a surgery appointment is clearly acting in the course of their employment, but a doctor who texts while driving their own car on the way home from work is clearly acting on a frolic of their own. Now, in 2012, Lord Phillips, in a judgment, said that the law on vicarious liability was, quote, on the move, and it's changed a lot even since then. We don't really know whether the law has stopped moving, but the rules on vicarious liability as they stand are actually quite straightforward. So our two questions have become: was there a relationship akin to employment between the defendant and the tortfeasor? And was there a close connection between the tort and what the tortfeasor was actually employed to do? All we need to do now is to understand those questions and to use a bit of case law to explore how we're going to answer them. So the first question we use for vicarious liability now is whether the person who committed the tort was in a relationship akin to employment with the defendant. Akin to just means like, so we're basically just deciding whether, taking account of all the facts, the relationship looks like the relationship between an employer and an employee. Our authority for the test of akin to employment comes from Barclays Bank versus various claimants, with a claim brought by people who were sexually assaulted by a doctor carrying out checks for the bank. In that case, the doctor doing the checks at his own practice and not at the bank, and at times arranged by the doctor himself, as well as the fact that the bank's main business was finance and not medicine, all led the court to decide that there wasn't a relationship akin to employment. If the akin to employment question is hard to answer, you might go to the judgment in Christian Brothers from 2012, sometimes called the Catholic Child Welfare Society v. Various Claimants, where the court gave 5 policy reasons why it's sometimes fair to hold an organisation vicariously liable. Now, it's really important that the court didn't, and still doesn't, use this as any kind of 5-part test that must be met for there to be a relationship akin to employment, but the factors might be useful if you're trying to work out whether that relationship is there. And those factors are that the employer is more likely to be able to pay compensation, the employee was likely to have been acting on behalf of the employer, the employee's activity was probably part of the employer's business, the employer created the risk of the tort by asking the employee to do the work, and the employer will have had some control over the employee's work. So, to summarise how we now tackle this first question for vicarious liability, our question is, was there a relationship akin to employment between the defendant and the tortfeasor, using Barclays Bank as our authority? And if we need to, we can go to those 5 policy factors from Christian Brothers to help. So that takes us to the second question for vicarious liability, that used to be the question about acting in the course of employment, which we now answer using what we call the close connection test. In other words, was there a close connection between what the tortfeasor was supposed to be doing and the tort they committed? Now we have 2 authorities because the courts developed this test in Lister v Hesley Hall. Then there was some uncertainty about it, but the courts have returned to it in Morrison's v Various Claimants. In Lister, the court decided that there was a close connection between a warden's employment at a boarding school and assaults committed against students while he was there. But in Morrison's versus Various Claimants, the court decided that there wasn't a close connection between a HR employee's work for the supermarket and his public sharing of confidential employee data. And in that case, it was largely because the employee uploaded that information actually as part of a vendetta against the company. So they decided they couldn't hold a close connection between what he was supposed to be doing and the tort that he committed. Now, even though we now use this close connection test, there's still some older case law that gives us some important clues for that second question on vicarious liability. So from Century Insurance v Northern Ireland Transport Board, we get the rule that a job done very badly, even extremely badly, can still be closely connected to the employment that the employee is paid for. For example, in that case, a tanker driver who smoked and threw a cigarette on the ground while delivering fuel to a petrol station. That can still be held to be closely connected to his employment. For Mohammed v W.M. Morrison, we find that an intentional or even a criminal act can still be closely connected to employment. So in that case, it was a petrol station attendant who racially assaulted a customer while he was working at the petrol station, and that was held to be closely connected to the tortfeasor's employment at the petrol station. And finally, from Rose v Plenty, that an action done against the employer's direct orders can still be closely connected to their employment. In that case, a milkman who allowed a child to help with a milk round even though he'd been specifically told not to do it. So to summarise how we now tackle that second question for vicarious liability, the question as it stands is, was there a close connection between the tort committed and what the tortfeasor was employed to do? And we can use Lister v Hesley Hall and W.M. Morrison v Various Claimants as our authority, with those 3 cases that we've just looked at, which really are just about removing defences from a defendant who might think that their employee doing their job very badly or criminally or against their orders might provide them with a defence to a vicarious liability claim. So now let's check our understanding of vicarious liability as it stands now by working through this scenario. Martha was a 16-year-old with no experience of working in catering. Along with her mother, Martha volunteered to help out at a village fair organised by the local church. When they arrived at the fair, Martha was asked by the vicar to help serve tea and cake to visitors. The vicar told Martha she was needed for 2 hours between 2 p.m. and 4 p.m, but could take a 10-minute break at 3 p.m. She was given an apron showing the church logo. While she was working, An elderly visitor to the fair complained to Martha about how long the tea was taking to arrive. Martha went immediately to get a pot of tea from the counter and poured it over the visitor's head, causing serious harm. So our vicarious liability question is whether the church can be held vicariously liable for the injury to the visitor's head that was inflicted by Martha. If you want to work through the scenario independently, then pause the video now and then hit play to get a worked solution. We're going to start with question 1 and ask whether there's a relationship akin to employment between Martha and the church using Barclays Bank as our main authority. Now, highlighted in green are facts that might give us clues about whether this is a relationship akin to employment or not. On the one hand, and this is what the church lawyers might argue, Martha was volunteering to help out at a village fair, which makes the relationship seem fairly casual, and it seems to just be for a one-off event. The fact that Martha had no experience might also work in that direction. However, neither of those facts are decisive. We could ask why the church was willing to have a volunteer with no experience or training, and just because someone isn't paid or because it's a one-off event doesn't necessarily mean they're not in a relationship akin to employment. And then we have other facts that clearly point us towards a relationship that is akin to employment. The church has provided a uniform, the apron, and the vicar, a church leader, has given clear instructions of when Martha will work and what to do, including when she's allowed to take a break. So if we imagine ourselves watching this scene unfold, we can ask ourselves whether it would look and sound akin to or like a relationship between an employer and their employee. I think it does. So the first of our two questions for vicarious liability is answered with a yes. Now remember, if we wanted to double check, we could also reflect on those 5 policy factors from Christian Brothers. The church is more likely than Martha to be able to pay compensation. Martha was acting on behalf of the church and as part of the church's business. The church created the risk of the tort by asking Martha to serve the tea, and the church did have some control over Martha's work. So those factors help to confirm our instinct that this is a relationship akin to employment. So then we need to move on to question 2 and ask whether there's that close connection between the tort Martha committed, pouring the tea over the visitor's head, and what she was employed to do. Now you can imagine that the church might argue that they clearly didn't employ Martha to attack visitors, but we know from cases like Mohammed v Morrison's that even committing a crime doesn't stop there being that close connection. But again, we have some clues that help us to decide on the close connection. Most obviously, Martha commits the tort or the attack while she's working at the village fair. But again, that's not necessarily decisive. However, she does pour the tea over the claimant's head in direct and immediate response to a complaint from the visitor about slow service. It's not like the pair had some long-standing rivalry and Martha attacked the visitor for other reasons. Martha also used the tools of her volunteer work to carry out the attack. She did it with tea from the counter. So these clues point us towards that close connection between the tort and the employment, and we can conclude that both the tests for vicarious liability have been met and the church would be vicariously liable for the injury. So you should now be able to explain what vicarious liability is, give a brief summary of some of the older tests for vicarious liability, and explain why they're sometimes still relevant. But most importantly, you should be able to apply the law on vicarious liability as it stands now through checking both for a relationship akin to employment and checking for a close connection between the tort and the employment. Hit subscribe to get notifications on new tutorial videos and follow the link in the description to lawstudyclub.co.uk where you can find up-to-date revision guides, case lists and loads more resources for A-level law.